Did you know that when you bring a lawsuit against a doctor for medical malpractice in the state of New York, you always have to bring in their medical group as well? Would you like to learn why? Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. There's something called vicarious liability. And vicarious liability in its most basic form means that the employer is responsible for the acts of the employee. So what does that mean? It means that if you have somebody working in a company and they do something that is careless, that results in harm to somebody else, the employer, the company, is going to be the one who's actually responsible for paying a damages award to the person who suffered the injury. That's known as vicarious liability. Now, I have in front of me something called the PJI, that's known as the Pattern Jury Instructions. And these are the instructions that the judge typically will read to the jury in a particular type of case. Now, I want to read to you the exact language that is here that talks to you about vicarious liability, because it's important to understand what the jury will ultimately hear in a particular type of case involving a company and an employer that may cause harm. So here we go. Vicarious responsibility. An employer is responsible for the act of his employee if the act is in the furtherance of the employer's business and is within the scope of the employee's authority. Now, what does that mean? Now, a lot of the language that you hear right now has a lot of nuances and interpretations. And what's important to understand is, in its most basic form, what that really means is, was the person who caused the harm doing so in the course of his employment? Did the injury happen while he was doing the type of work he was supposed to be doing? If the answer is yes, then that's an important factor for the jury to consider and understand as the judge continues reading this particular section. An act is within the scope of an employee's authority if it's performed while the employee is engaged generally in the performance of his or her assigned duties, or if the act is reasonably necessary or incidental to the employment. So basically, the jury has to determine whether or not what happened was during the course of the actual employment. Were they doing what they were supposed to be doing? The employer need not have authorized the specific act in question. Now, there's additional information here and instructions that the judge will give to the jury, but again, it's important to understand that vicarious liability simply means that the employer is going to be responsible for the acts of the employee if they were careless and caused somebody else harm. So why do I tell you about this? I tell you about this to give you an insight and an understanding into what goes on in evaluating a case and understanding the people that you have to sue in a particular medical malpractice case in New York. Chances are you have questions and concerns about your particular matter, so what I encourage you to do is pick up the phone and call me. I answer legal questions like yours every single day. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks so much for watching.